It's all right, don't worry about it. With all the cross appellants, cross appellees, there's no way to know who's right.
Oh, we're going to need the text now.
All right. Our next case, we have Alexander v. the North Carolina State Board of Elections. And I understand we have appellants and cross-appellees, appellee, cross-appellant. How do you plan to split your time? Do you need rebuttal?
Yes, Your Honor. We'll be split into the time, 20 minutes for the state board defendants and 10 minutes for the legislative defendants. And the other side will be starting and doing rebuttal, and we'll just go in the middle.
Okay, thank you. Counselor?
Your Honor, I'd like to reserve 10 minutes for a rebuttal under this, under the limited time we're given. If it please the court, my name is Robert Hunter. I am of the Guilford County Bar. It's my pleasure to represent the appellants in this matter. I would like to introduce the appellants, some of the appellants to the court. They're with me here today. They are judges in the state of North Carolina. Some are district court judges. Other is just recently received an appointment as an immigration judge and is a federal judge. Kelly Alexander is also a party to this. He is a state legislature and a longtime civil rights activist in Charlotte, North Carolina, where he has been elected, I think, to 10 terms in the legislature. He has been a client of mine before now. The parties, the appellants in this matter, are seeking a redress of grievances for the stigmatization of racial segregation brought about by a statute passed in the legislature. I hope your honors will take the time to read their affidavits of the effects that this statute, this unconstitutional statute, had on their lives that are found at the record at page 495 to 511 and 751 to 761. This is a case of both federal and state constitutional dimension. And it touches on the administration of justice in North Carolina. I wanted to say that this case also, this jurisdiction, this court has final order jurisdiction to consider our appeal. In this case, we have a case of mixed constitutional law. We have a case of mixed state and federal constitutional law. And when we have these claims, and I'm only going to talk generally about federal law in this particular appeal, although I'll be happy to answer any questions that may arise under state constitutional law. When a state court, including this court and the trial court, reviews federal claims, it reviews them under federal law, and state claims under state law.
Actually, and sort of stopping you there and moving to the mootness doctrine, and I'm sure there are other points you'll want to get to, but is there a difference in how, or I guess the undergirdings of the mootness doctrine at federal law versus state law? Is there a difference? Is it more jurisdictional is it more of a jurisdictional question at federal law than it is at state law? At state law, is it more of sort of an administration of justice piece? There seems to be at least hints of that coming through in the briefs.
Yes, sir. Thank you for your question. Absolutely on point, as I would expect. The federal is jurisdictional. State is a matter of judicial discretion, and that's the difference. If you look at the recent cases from this court in Chavez that was reviewed by the state Supreme Court, and in Peoples, if you read that case written by Justice Sharp, it is a matter of judicial deference in the discretion of the court. But if it involves an important state constitutional question and a question of public interest, as we do here, in racial discrimination, in election of judges, yes, it is a matter of public interest. The public is interested in people who make findings of fact, and district court judges make findings of facts and act as jurors in millions of cases in North Carolina every week. And we do not expect our jurors and our finders of fact to be elected along or selected by the legislature or the people in a racially discriminatory system. So that, yes, if you read Justice Thomas's recent opinion in two names I can't possibly pronounce, something like Uzbekistan versus Luzinski, he talks about the mootness doctrine in a case from 2020. And he talks about that case and how the mootness doctrine applies in federal court. But you don't have to go to the Supreme Court to do that. Justice Edmonds and this court had a discussion of those cases in Comer versus Amons. And they adopted for jurisdiction in this state court the federal standard that the Supreme Court used in County of Los Angeles versus Davis, 440 U.S. 625. So, and the Comer versus Amons site, which is in our briefs, is at 135 North Carolina 531. And that is, the federal standard is different in this regard. If cessation of an illegal activity by the state can be repeated, if it's a recurring thing under that arm of the mootness doctrine, which has to do with recurring but evading review. If that exception or public interest exception applies, the federal rule is that if you have if it's capable of repetition, that is to say that if it can recur, if there's not a declaration that they can't do it anymore, if a judge doesn't declare the law in that instance and give people guidance, including the legislature and voters, on that racial segregation in election districts cannot continue. And that's what we asked for. We got a lot of the relief we asked for. But these people are judges. They don't just want the right to run for office in one election. They and their voters want a right to have the judges of this state declare what the state constitution means and declare what the federal constitution means with regard to dividing up urban counties for partisan or demographic or political gain. And that's what we have to have. Now, I have explained in my brief what the state constitutional argument is, but today I want to talk about the federal claim, the 15th Amendment claim.
Just to circle back before you get to that, just to maybe clarify my question, which is, are we to apply a different mootness analysis to the federal claims versus the state law claims?
You can apply, in my view, given the latest wisdom from the North Carolina Supreme Court on that in Chavez, I think you can apply either one and come to the same result. But others disagree with that, and you'll hear from them about their view of the mootness doctrine. So I want to talk a little bit, or a good deal, about what I think is the seminal case that should have been applied by the lower court. Now, the lower court, on this one point you just raised, if you read their order, they only cited to state cases. They did not cite to the federal cases. So one assumes from that that they didn't apply the federal law. That is the error that needs to be corrected by this error-correcting court. So, now, what I want to talk to your honors about today is a case called Gamilion versus Lightfoot. This is a 15th Amendment case from 1960. It has never been overruled. It has never been distinguished. It was written by the most conservative Supreme Court justice that will be in our lifetime, which was Felix Frankfurter. He didn't even believe in the Equal Protection Clause and one person, one vote. This was written before all of those cases came up, and it was about Tuskegee Institute and the Alabama case. If you read that case, the parallels to that case and this case are eerie. In that case, the holding is, and I hate to read this to you, but I'm going to, the 15th Amendment to the Constitution of the United States forbids a state from passing any law which deprives a citizen of his vote because of his race. The opposite conclusion urged upon us by the respondents would sanction the achievement by a state of any impairment of voting rights, whatever, so long as it was cloaked in the garb of the realignment of political subdivisions. It is inconceivable that guarantees embedded in the Constitution of the United States may be thus manipulated out of existence. Now, I want to show you a map of Tuskegee that was attached to the Supreme Court's decision. This is the irregular shape of the Tuskegee map that in and of itself was sufficient for the court to find a violation of law here. Now, not all African Americans were gerrymandered out of Tuskegee, Alabama. 4 were kept in Tuskegee. The others were not. And that's what I want to talk about in showing you the maps that are here, which are much more egregious. This is a map of the Mecklenburg County District Court districts, which was generated by this particular piece of legislation. Those are the lines, and this is a map that shows the racial composition of the precincts. The lighter color shows where the majority, or the lighter the color, the more African Americans are there. These clients were put in districts that were predominantly white. Some, they were incumbent superior district court judges or candidates for judge, and they and the other voters, we have standing because we have other clients, other plaintiffs that are in other sections of the county. So we have federal standing to bring these claims. Now, the 15th Amendment applies to judicial elections. I brought a case called Haith versus Martin, which is at 615 Federal Supplement 825, in which the 3-judge panel here in North Carolina found that the 15th Amendment applies to North Carolina judicial elections. I've also brought, my client Kelly Alexander brought a case called Alexander versus Martin, which was settled by the North Carolina General Assembly with a payment of attorney's fees, which dealt with creating judicial subdivisions for superior court judges across the state based upon a finding at that time in the 1980s of significant racial voter polarization in all the urban counties, because at that time white voters suppressed the voting rights of African Americans by using at-large districts. So in those things, and our Supreme Court has also used the same law in Stevenson versus Bartlett in instructing courts to follow and apply federal law to federal claims and state laws to state claims. The 15th Amendment claim occurs when a right to vote is abridged. The word abridged has been defined as shortened by Justice Scalia in the case of Reno versus Bossier Parish 2, a 2000 case involving retrogression analysis. But it also, in that, he distinguishes between how do you go about proving a Section 2 claim or a constitutional claim. You do it the same way they did in the Gamilion case. That is to say, you look at a hypothetical ideal district. Now, there are all the other districts in the state of North Carolina elect their district court judges at large. Up until this statute passed, Mecklenburg County elected its district court judges at large. Today, there are 3 districts, Wake County, Union County, and Vance and Henderson, the 9th district, where district court judges are divided up.
And you would agree, I think, that as a general proposition, taking away any potential racial gerrymandering of those districts, that the General Assembly would have general authority to construct judicial districts in North Carolina?
Depends on how you read Article 4. Article 4 of our Constitution requires a uniform system, not a divided system. And we have a state statute, which we've cited, which says all the judicial district court, local court districts are to be constructed of whole counties. So no, I wouldn't agree with that. And that's one of the issues you can reach in this case, should this panel choose to do so. We've asked for a declaration about the state claim, but I'm more concerned today about the federal claim because it's clear, even if they do have that power, which, and it's not, if they cite the Preston case as being the case that says they have all the power they need to divide up the districts. But Preston has been modified by Stevenson versus Bartlett, and the Blankenship versus Bartlett, which says there are limits to what the General Assembly can do, constitutional limits to what they can do. So no, I would not agree on that. But I do say that in any hypothetical district that you might have, their votes went from 21 votes, where the minority African-American community in Mecklenburg County had an equal chance with everyone else. Everyone had the same chance, to a reduced chance. So there was an abridgment here. Now, in fairness to my friends in the legislature, they did agree to not have this particular scheme, and they did away with it. But that doesn't stop them from doing it again. I have been through so many of these cases where we didn't get a consent order, or we didn't get a declaration from the judges, and the legislature, when it changes hands or some new group of adversaries goes to the legislature, they will go in and reinstitute new ways of discriminating against their political opponents. And this was simply, that's what it is. Now you say, well, the legislature can do that, can't they? Aren't they allowed to advantage their political party in their legislation? No, not if it's racial. Remember that the 15th Amendment was passed because the 14th Amendment wasn't working. In North Carolina, they had the Kirk-Holden War. The Klan ruled a great deal of the state. And the Anti-Ku Klux Klan Act of the 1870s was done specifically to do this, and followed that with the 15th Amendment. The 15th Amendment was not only designed to protect people based on race, it was their political allies as well. So in the legislature, and I don't give a darn if it's a Republican group that's being discriminated against by Democrats or Democrats against Republicans, whenever the legislature rears its head and decides to take a whack at their political opponents, I think it's unconstitutional.
So as you're talking, I'm articulating very well the argument. My mind is starting to wander a little bit off the mootness doctrine into more of sort of a case in controversy. It's almost, you know,
We don't have cases in controversy.
and
We have, if you read Justice Hudson's recent opinion in Impact versus Committee to Elect Dan Forrest, we only have justiciable issues in North Carolina. But this is a case in controversy because it arises under the U.S. Constitution. So we meet either the state or the federal standards for jurisdiction.
even though there's no sort of, you know, I'm thinking more of an earlier Justice Hudson case when she was on this court, or and before that, I guess it was Justice Parker in the Supreme Court with Malloy v. Cooper, dealing with declaratory judgment actions and when they're properly brought. And there, it was enforcement of a criminal act. It was like there needed to be some sort of imminent threat that this was going to be.
Well, our Constitution provides for every wrong, there's a remedy. And this is a wrong for which we're entitled to a remedy. And we're entitled to that remedy under federal law.
And to be clear, though, in the complaint, the remedy you request, obviously amongst many, one is a preliminary injunction, right? And then the permanent injunction request is specifically if the General Assembly does not remedy this.
But we also ask for a declaration in our complaint.
And so this is your, at this point, you would agree the injunctions are gone,
Right.
just focus on the declaratory judgment.
Right. We want the declaratory judgment action done because if we don't get it under federal law, they're just going to do it again. And I don't bear any animosity to the legislature and what they're doing in the sense that the individuals in the legislature, but we just had this, I don't know if you've had a chance to read the court's opinion in your Holmes versus NAACP versus Holmes versus Moore opinion, but Justice Rozier has really honed in on this one point, which comes up in the case of NAACP versus McCrory. It's not whether or not individuals in the legislature hate blacks or reds or yellows or whatever. It's whether or not the legislation purposely targets a group of voters. And that's what it is clear from the visual evidence I've just showed you under federal law that the legislature did. I'm going to save the rest of my time for rebuttal.
Good afternoon, Your Honors, and may it please the Court. My name is Sarah Boyce, and I'm counsel for the North Carolina State Board of Elections and the other state board defendants. I'll be sharing time today with counsel for the legislative defendants, Mr. Tom Farr of Nelson Mullins. I'm planning to speak for 20 minutes, and Mr. Farr will speak for 10. This case raises a textbook example of mootness. The plaintiffs have sought two primary remedies. First, they've asked for a judgment declaring Session Law 2018-14 unconstitutional. Second, they've asked for an injunction barring any elections in Mecklenburg County from proceeding until the General Assembly returns to countywide judicial elections in that county. The problem with these remedies, of course, is that they would be meaningless at this point. The General Assembly already repealed the legal provisions that the plaintiffs have challenged more than a year ago. And in so doing, the General Assembly returned Mecklenburg County to countywide judicial elections for district court judge judicial elections. Because of these changes, this case is plainly moot. Nothing this court or any other could provide as a remedy at this point would have any practical effect on the parties here today.
But I've just heard counsel for your opponents say that they are seeking the declaratory judgment that this type of judicial division not be done again. So no, it wouldn't affect the parties before us, but it would prohibit the legislature from doing the same thing in the future. Why is that not something in public interest?
So, Your Honor, the public interest exception has been applied a few numbers of times in the North Carolina courts, but I don't think it would apply in this particular case. And before I delve into that, I want to note, Judge Hampson, that my response to your question about whether state law or federal law would apply here would be, I think, similar to my friend on the other side's. I think it's clear that state law controls here, and that mootness for purposes of the state courts is not jurisdictional. So, for that reason, things like the public interest exception can apply. The judiciary can choose within its discretion to hear certain cases that would otherwise be moot. But to answer your question, Judge Collins, I don't think the public interest exception would be appropriate here. I certainly think my friend on the other side has an argument that this case involves a matter of public interest. Elections of judges is a matter that the public cares quite a good deal about. But we know from cases like Anderson versus the State Board of Elections and the Cape Fear case that simply involving a subject matter of great public interest is not enough. There must be more to trigger the public interest exception than simply a question of public interest. And from the North Carolina Supreme Court's decision last year in Chavez, we get some clue as to the other factors that should play into a court's decision to nevertheless hear a case that might be moot. The two factors that seem the most significant are whether, in fact, the court's decision would have a practical effect on other parties beyond the ones in the present case. And here it's not clear at all that the court's decision would have the broader impact necessary to proceed. We know from the record in this case that there are 3 other counties that have these countywide elections, but it's not clear if this court were to resolve, or the lower court were to resolve, the federal claims in this case, that it would have any bearing on those laws because of the fact-bound nature of the federal claims in this case. For instance, the equal protection claim requires the court to look at the disparity in voting power across a county. The disparity in voting power in Mecklenburg County would be irrelevant to the disparity in voting power for the districts in Vance and Union and Wake County, the other counties that have these kinds of laws. And similarly, with respect to the racial gerrymandering claim, looking to the legislature's intent in dividing Mecklenburg County is not going to send a signal one way or another as to whether the legislature acted improperly in dividing Wake, Union, and Vance County into separate districts. So if this court were to enter a declaratory judgment here, it's not clear what impact it would have on any existing law moving forward. It is, of course, perhaps true that there would be some minimal signal to the legislature that if in the future they decided to enact this exact same statute and divide Mecklenburg County up, it might provide some guidance there, but that's never been sufficient in any state court decision that I'm aware of or any federal court decision that I'm aware of to allow a court to proceed with a case that would otherwise be moot. I haven't heard my friend identify any case where a statute was repealed and the speculative possibility that the legislature might enact a similar law down the road was sufficient to trigger the court's jurisdiction or the court to move forward with resolving a case that's otherwise moot.
And that seems to be part of the dividing line here is there does seem to still be this element of some form of capability of repetition. And I suppose we're like, where on the spectrum does that fall? You know, is it probability of, or is it truly just there is some potential that this could be repeated in the future? And so, where does that fall on the spectrum?
Sure, Your Honor. So I do want to be careful to delineate between the two different exceptions that we're talking about here. And I think in my friend's brief, they acknowledge that this doesn't really fit within the capable of repetition but evading review scenario, because for purposes of that doctrine, you have to prove that it's likely that these same plaintiffs are going to be subject to the same harm. And I don't think there's any evidence at all to support the idea that this is likely to recur. Again, I'm aware of no case that infers that a legislature might again enact the same statute and that that's sufficient to trigger that exception. If we're talking about the public interest exception, again, what the court has tended to look at is the extent to which a decision would have a practical effect on a broad swath of other parties. And I think the Chavez decision is helpful in ascertaining the scope of the exception. There, the court made clear that there were at least 6 other law enforcement agencies that had similar agreements such that a large portion of the state would learn something or be able to glean something from a decision if the court chose to proceed. And so for that reason, and the additional reason that the case seemed to implicate a subject that would usually have a short fuse, it would often be difficult for the court to act swiftly enough for any case to avoid being mooted. Those two considerations counseled in favor of applying the public interest exception in that case. Here, neither of those things are the case, because again, if this court moves forward on resolving the federal claims, it's not clear that doing so would have any implications for any of the other 3 counties that continue to have these kinds of laws on the books. And there's no reason to believe that another case, if it were pursued on behalf of Wake County plaintiffs, Vance County, or Union County plaintiffs, would be mooted out before the court could come to a conclusion. So the proper course...
I just want to jump in. So put aside those 3 counties that still have these subdivided districts. There are 97 counties that potentially could be subdivided, correct? And we've seen a lot of legislative maneuvering with our courts. Is it possible that sending a signal that racial gerrymandering in judicial districts is not appropriate would then somehow save 97 other counties from being similarly situated?
Your Honor, it's certainly possible that an opinion from this court could send a signal, but respectfully, I don't think that's the proper question. The proper question is whether this is a unique enough situation that this court should ignore the fact that this case would otherwise be moot and nevertheless proceed under the public interest exception. And here, I don't think any of the extenuating circumstances that usually cause the court to reach out and resolve an otherwise moot case are present. There's no reason to believe that my friend here could not bring a similar case on behalf of Wake County plaintiffs, Union County, Vance County plaintiffs, and get the same guidance or signal from this court that would be possible here. So,
unless the General Assembly rescinded that legislation too, before we could get to a final decision.
Sure, that would be a possibility, though. Again, in that instance, they would be getting exactly the same relief that they sought here. So, if their purpose were to simply wipe all these laws off the books, that would be one way of doing it. But again, I'm not aware of any case where the value of guidance or the mere speculative possibility that a General Assembly would act again was sufficient to trigger the public interest exception. I think I can count on, maybe it would take 2 hands to get to the number of times where that exception has applied, and in all of those, it's been an instance where the case had an unusually short fuse such that it couldn't have been resolved elsewhere.
And that's what I kind of want to get to in the context of elections specifically, because clearly, elections can have a short fuse, right? I mean, they happen every couple of years, and it's possible that a General Assembly can enact a law that creates judicial districts or takes some impact, affects one election. That's challenged, the election's held, or get the preliminary injunction for next time, the law's repealed. And that can happen over and over again. For that matter, the State Board of Elections can interpret things on absentee ballots for one election and then revoke that guidance after the election, for example. So why is it that elections are not sort of inherently that sort of short fuse issue that we need to address as a court system and put parameters around what is proper and what is not under the 15th Amendment and the right to vote?
Your Honor, I don't think there's been any broad exception carved out for elections. It is certainly true that sometimes there is a short fuse. Here, you could have a window of several years in which to resolve a dispute. And for the counties that have laws still outstanding on their books, they've been around for nearly decades. There's no reason to believe that a case would have been mooted out before it could have been decided. So again, we know from cases like Anderson versus State Board that the simple fact that a case involves elections, despite the ephemeral nature of an election, is not sufficient ordinarily to carve out a categorical exception for things that involve a subject matter of that kind. So perhaps if my friend tried to bring another case, and again, that was mooted because of the nature of the election. Of course, that's not why this particular case was mooted, because of the election. But if it turned out that that was a recurring problem, that might change the calculus. Here on this record, I don't think there's any reason to believe that the simple fact that this involves elections is going to repeatedly lead to other cases of this kind being mooted out before the court could resolve the issues. So I do want to emphasize just how rare the court's invocation of the public interest exception has been, and how exceptional it would be for the court to apply that exception where the General Assembly itself has acted and repealed the statute that has been enacted in this particular case. If the court doesn't have further questions on mootness, I'd like to move quickly to attorney's fees as well. The court below granted plaintiffs' attorneys' fees because it found that they qualified as prevailing parties under Section 1988. That decision was problematic for two reasons. First, the three-judge panel lacked jurisdiction to award attorney's fees. And second, even if the panel had jurisdiction, binding precedent from the U.S. Supreme Court makes clear that the plaintiffs cannot qualify as prevailing parties. Most notably, Buchanan versus the West Virginia Department of Health and Human Resources makes clear that a plaintiff can qualify for attorney's fees only if they've managed to secure actual relief on the merits of their claims that materially alters the legal relationship between the parties. Plaintiffs have not secured that kind of relief here and are therefore ineligible for fees. Because the three-judge panel lacked jurisdiction and because the panel wrongly concluded that plaintiffs were prevailing parties, the fee award must be vacated. I'll start briefly with jurisdiction. As Your Honor's decision in Haley versus Tropic Leisure Corporation makes clear, attorneys' fees are not the sort of decision that a trial court retains jurisdiction over following a notice of appeal. And in this particular case, the three-judge panel's decision to award fees was subsequent in time to the filing of the notice of appeal related to mootness and summary judgment in this case.
And specifically here, because fees were sought under Section 1988, which is a prevailing party award.
Precisely,
right?
Your Honor, yes. Because North Carolina Statute 1-294 says that the trial court can retain jurisdiction over anything that would not be affected by appeal, the standard becomes particularly relevant because the nature of the prevailing party standard necessarily means that the appeal can affect who is worthy or not worthy of attorney's fees. And so when that standard is triggered, the trial court lacks jurisdiction to enter a fee award after a notice of appeal is filed. The second reason that I think there was a jurisdictional problem here relates to it is supported by the memo of authorities that I filed yesterday morning, and I apologize for the late-breaking nature of that. But I did want to note that Rule 42, the rule of civil procedure that relates to three-judge panels, seems to strongly suggest that the three-judge panel was the improper court to resolve the issue of fees in this particular case. And if Your Honors do have that memo in front of you, I would direct you to page 5 of the appendix, where I included the text of Rule 42. If you look at the last full sentence on page 5 of that appendix, it reads, "The court in which the action originated shall maintain jurisdiction over all matters other than the challenge to the act's facial validity."
Can you tell me which page again?
Yes, sure. It's appendix page 5, the last complete sentence, starting the court in which the action originated.
Got it.
I won't waste your time by reading that sentence again, but I think what it makes clear is that the three-judge panel is supposed to have jurisdiction only over the narrow issue of the facial validity of the law. All other issues are supposed to be retained by the trial court. So if this court vacates the fee award, as we urge it to do, I believe the proper course would be to send the question of fees back down to the initial trial judge rather than the three-judge panel, with guidance from this court that makes clear that a fee award would be inappropriate in this case. And I'll briefly go into why I believe that is. So we know from the U.S. Supreme Court's decision in Buchanan that the only scenario in which a plaintiff can secure attorney's fees is if they either have an enforceable judgment on the merits or a consent decree. And here, plaintiffs lack either of those things. With respect to the first, an enforceable judgment on the merits, we know that a wide range of different judgments can qualify. It might be a permanent injunction, it might be summary judgment, it might be judgment following a trial on the merits, but none of those things are present here. My friend, Justice Hunter, has seemed to suggest that perhaps the consent order in this case was akin to a preliminary injunction, but that's simply not the case. The plaintiffs asked for a preliminary injunction and were not granted one. They asked for a TRO and were not granted one. Instead, in lieu of those remedies, they had this consent order. So there's no evidence in the record that any court ever concluded or confirmed the merit of plaintiffs' claims in the manner that's necessary to qualify for a fee award under Buchanan and the other family of cases like it from the U.S.
Can a consent
Supreme
order
Court.
ever arise to that level of establishing the prevailing party for purposes of fees?
A consent order can, Your Honor, but I don't believe a consent order of this particular kind, a temporary interim consent order, can. And the reason that we know that is Buchanan. As an appellate advocate, often you're placed in the uncomfortable position of trying to analogize between cases and say, my case is more like this one or more like that one. And this is the rare instance in which we have a Supreme Court case that is exactly on all fours in terms of the procedural posture. What happened in Buchanan is that the state was enforcing a law. The plaintiffs raised a constitutional challenge to that law, and while the litigation was pending, the state agreed to cease enforcement of the law by way of an interim consent order, exactly like happened in this case. And the U.S. Supreme Court nevertheless concluded that the plaintiffs were not prevailing parties sufficient to satisfy the Section 1988 standard. And the reason for that is because cases like Mayer from the U.S. Supreme Court have made clear that a consent decree should qualify a plaintiff for attorney's fees only in a very narrow circumstance, and that narrow circumstance is where the consent decree finally resolves the case and the court retains jurisdiction over it, such that the consent decree with the court's judicial enforcement has influenced or has affected a lasting, binding alteration of the legal relationship between the parties.
So switching gears a little bit then, so does that not inform our analysis under the mootness doctrine? I mean, isn't there a connection there between saying, well, if this was just, sort of a temporary interlocutory consent order that doesn't resolve the merits because it's not binding, there's no enforcement, there's no long-term enforcement mechanism, there's no continuing court jurisdiction for enforcement because you don't have that final judgment. Does that not inform the analysis on the mootness side as to whether, in fact, there may be circumstances under which we need to get to a final judgment for the declaratory judgment action here? I mean, it seems a little bit in tension to say, on one hand, this is way too preliminary, way too early, it doesn't count, even though ultimately legislation was repealed, it's never going to be done again, to, well, you don't get attorney's fees because it was really temporary.
No, Your Honor, I don't think it alters the calculation. I mean, it is always going to be the case when a General Assembly chooses to repeal a statute that they could go back and do that again as long as the reason for the repeal wasn't a court, and yet that has never been sufficient for purposes of resolving a case that would be moot. So I don't think those are in tension. Here, the interim consent order was essentially a private settlement between the parties, simply to put things on hold while the case was resolved. And that does not give rise to attorney's fees under Buchanan. But I don't think that the temporary, I think the two different inquiries have to be separated out. I don't think that the simple fact that the legislature was willing to pause things briefly while this case was proceeding should alter the calculus as to whether or not the General Assembly is likely to enact a similar statute moving forward. And again, of course, because there are these other statutes on the books, the plaintiffs have every opportunity if they want to proceed with their Unified Judiciary Clause theory, or if they want to try to continue to pursue the public interest of racial gerrymandering claims, to do so in those cases, in those particular counties where those laws remain on the books. I should pause there unless the court has further questions for me, and reserve the rest of my time for my friend, Mr. Farr. Thank you, Your Honors.
Thank you, Your Honors. May it please the court, my name is Tom Farr. It's an honor to be here today, and it's an honor to represent the Speaker and the President Pro Tem of the Senate. With me today is my partner, Alyssa Riggins, who is the brains behind this operation. I'm grateful that she's with me today. I think one thing that we've kind of resolved here, I thought this appeal was mainly about whether the consent order conferred prevailing party status under 1988. My good friend, Mr. Hunter, who has been not only my good friend but my mentor for probably about 40 years, mentioned nothing about the consent order conferring prevailing party status on his clients, and that's because he is unable to distinguish the facts of this case from the Buchanan case. So I think that's been resolved. Now I want to jump right into what seems to be of most interest to the court about, is this capable of repetition, and should the court provide guidance? First of all, there is no need to provide guidance because the case law on racial gerrymandering is extremely well established. There's probably 30 cases by the United States Supreme Court that explain the elements that you have to prove racial gerrymandering. So you don't have to tell the legislature that you can't racial gerrymander judicial districts, because they already know that you can't racially gerrymander judicial districts. Another thing that seems to be strange about this argument is that there's almost an assumption that these districts were racially gerrymandered. And the fact of the matter is, my clients strongly dispute that they were racially gerrymandered. We gave a affidavit from Senator Bishop, who was the principal author of the act, and he contends that race did not enter into his decision-making, that his decision-making was based on trying to eliminate gross disparities between Superior Court districts in Mecklenburg County, and then aligning the district court districts with the Superior Court districts, and then appointing judges to multi-member districts to basically address the idea of not double bunking judges. I don't know if you're familiar with that term, but that's a term that's used when...
We're familiar.
Okay. So there's strong argument on the part of the legislative defendants that this was not a racial gerrymander.
But I don't think it's so much that it's an assumption that there was racial gerrymandering. I think it's simply a product of the procedural posture of the case, right? I mean, the question we're sort of trying to decide here is whether this case, which makes those allegations, should proceed forward, after the General Assembly has now repealed that act. So I don't think any of us are prejudging the evidence here. I think we're simply dealing with the case in the posture it's in.
Well, then the next point, Your Honor, is why didn't Mr. Hunter schedule this for a summary judgment or a motion for preliminary injunction in the court below? Because what we've had today is essentially a summary judgment hearing where we've been putting maps up that I'm not sure I've ever seen before. I could be corrected, but I don't recall seeing some of the maps that were put up by counsel. And he was arguing about the density of the black population in Mecklenburg County. These are all sort of disputed factual issues that should have been presented to the Superior Court, either in the form of a preliminary injunction motion or a summary judgment motion or a trial. And that didn't happen. There was never any notice of hearing on a summary judgment motion. And I think you all are very familiar with the case law that says we were entitled to 10 days notice of a summary judgment motion. We objected to the court considering Mr. Hunter's summary judgment motion, and they never ruled on his summary judgment motion on the grounds that it was moot. So he's asking you to conduct a summary judgment motion here, and he's focused on the federal claims because he's not entitled to attorney's fees under the state law claims. And as we have explained in our brief, it's our view that if you were going to grant summary judgment, which I don't think you can or should, we would be more likely to get summary judgment on the state law claims than Mr. Hunter's clients would be, for the reasons we cited in our brief. And
that was part of my question to Mr. Hunter was, are we to employ a different analysis, I mean, really under the mootness doctrine was my question, to the federal claims versus the state law claims?
Well, thank you for asking me that question because, first of all, I think it's precious rare, if any, cases where our courts have proceeded to enter a ruling on a repealed statute. The overwhelming authority is that that's not appropriate. There is a case, I think it's called the Sound River case, where the Court of Appeals has said that when a statute is repealed, it becomes a non-justiciable question, and the court doesn't have subject matter jurisdiction. So there is a case by this court holding that, but I would also say, Your Honor, that this is a federal claim. If we were in federal court, the federal court would hold this was non-justiciable. How is it that a state court can find justiciable and not moot a federal question that federal courts would find non-justiciable and moot? That doesn't seem to be possible to me. So I do think under the circumstances of this case, I don't think it's quite as strong on the state law claims. But on the federal law claim, I think you do have to apply the federal rule on jurisdiction. Because certainly if he had brought this case in federal court, the Eastern District of North Carolina would say that the case was not justiciable and they had no jurisdiction once the legislature repealed the statute. So I would just say, Your Honors, that the facts in this case that's been presented today by counsel have been akin to a summary judgment hearing that we were not given the opportunity to have. And if for some reason you think this case should go forward, the only remedy is to remand the case for further proceedings below. And as we've explained in our brief, you also have to vacate the award of attorney's fees because you're not entitled to attorney's fees for a preliminary injunction if the preliminary injunction is vacated ultimately by a final judgment. So unless the court has any questions, I would like to sit down. Thank you.
Thank you.
I was thinking today about my legal career on the way to court, and I'm a 15th Amendment person. For 40 years, I have been doing the 15th Amendment work, beginning with Jingles versus Thornburg. My good friend, Mr. Farr, who's an excellent lawyer and has represented the state in numerous occasions, and is a wonderful lawyer, is more of a 14th Amendment man because he wants to balance the equities. He is mistaken about the fact that he hasn't seen the maps that I put in today. The Tuskegee map is a map that was attached to the Supreme Court opinion in Gamilion, so it was not put in my complaint. But all the other maps are in the record, and they are well acquainted with them. They, and an affidavit from an empirical professor who Mr. Farr has used and has recognized as an expert in the field, gave proof of the evidence of racial motivation and intent by the General Assembly. We had verified complaints that we gave to the court from the very beginning of this case, and we had facts before the court that they were well aware of in August of 2019.
I think the underlying point for Mr. Farr, though, is that assuming we get past the mootness question and find the case not moot or an exception to the mootness doctrine, you've invited this court to enter judgment on the merits, as I understand.
Yeah, because I was denied the court. First of all, you don't need a hearing. You're not entitled to a hearing on a summary judgment matter. You may have one under the rules. Secondly, they didn't put on any counter evidence. I put on a prima facie case. My prima facie case is in my complaint. It's sworn to, and we've added evidence to it since then. And it's never been controverted. They have never proffered any realistic hope of overcoming with a compelling state interest why racial segregation is still a legitimate vehicle for judicial elections in North Carolina. They've never put up any evidence. They just want to delay the case. I want to thank my friend from the State Board of Elections for her presentation. She has adequately described the dilemma that civil rights lawyers have faced in this state since the 50s. You'd go and try to get public accommodations, and you'd bring your case, and 2 years later, they'd repeal the statute and it would be moot. The whole reason for Section 5 of the Voting Rights Act, which no longer applies, is exactly for this sort of circular, let's hold the cheese out, give them something, but let them exhaust themselves in perpetual Jordache versus Jordache pleadings before a court to get basic justice, while the General Assembly merely continues to violate the Constitution, both federal and state. Now, if she wants a decision where a case was moot and yet the court went on to do it, read In Re Peoples by Justice Sharp. Justice Sharp asked a question in Re Peoples, which is relevant to this case, and that is, what would be the quality of justice if Judge Peoples' conduct was allowed to go unremedied, uncommented on, undeclared? And I'll ask you the same question. What is the quality of justice if finders of fact are selected and the legislature is not prevented from using racial discrimination to select our judges? What's the quality of justice for that? I know what it is, and you know what it is too, because black people won't be able to get justice, and it won't feel like they've been able to get justice. The problem with segregation here is not some equal protection problem, it's the stigmatization. Read Bethune-Hill versus Virginia State Board of Elections by Justice Breyer just this last time. Now, I want to take a few minutes to talk about, and Bethune-Hill sets out the prima facie case I have made under the 14th Amendment.
I want you to answer a question for me, either now or when you finish what you're going to say. Can you distinguish Buchanan?
Yes.
All right.
After Buchanan, Lafemme came in. And if you read the court's order, that's what they relied on. And this is what Judge Boyle relies on in the Eastern District, in the cases that the panel below cited and I cited in my briefs. Lafemme says that when you're looking at that their ruling elevates form over function, and that what you have to look at is answering the question whether or not the legal relationship between the parties was changed as a result of a court order. If so, you are a prevailing party. Now, if you don't think I've done enough to get the legal relationship changed by the three-judge panel, they did, because they awarded me prevailing party status. But let's assume, for purposes of going forward, that I still want my declaration. A declaration of right would be a clear, definitive change in the relationship, the legal relationship. That's why it's important. It's not just important to base the attorney's fees, it's important to stop the unconstitutional behavior. Citizens of North Carolina shouldn't have to go to the federal courts for relief of their constitutional rights. We ought to be able to go to state courts and have state courts apply federal law to get relief, and have those rights paid for if they have to hire an attorney. Why should they have to bear the rights of doing it? This scheme, this old segregationist scheme that the Attorney General of North Carolina is urging on this court, and I mean that in all charity to this young lady, that it is capable of repetition. We're not dealing with just an occasional ephemeral election here. We're dealing with an election structure. For example, how long has the division in Union County, where you vote, Judge Carpenter, been, where you've had a tiny little district for one district court judge that was put in by a Democratic senator to punish the Republicans? I mean, this is not one-sided. This is not just the Republicans picking on the African Americans. This is Democrats picking on Republicans. This is racial gerrymandering, which is prohibited by the state constitution. But if it's not prohibited by the state constitution, this particular kind of gerrymandering is void under the 15th Amendment and Gamilion versus Lightfoot.
So if we were to determine, I know you're getting short on your rebuttal time, but if we were to determine the case was not moot and it went back for hearing on the declaratory judgment claims and you did not prevail on the final judgment, I mean, I mean, A, what practical impact does that have, you know, for your
Why would
client
you do
here?
that? Why wouldn't you go ahead? There's no evidence on their side. I've made out my prima facie case. You would declare the rights of the parties and then mandate that they enter an order on that. And if you want to remand but not vacate the order of the three-judge panel for reconsideration by one or three judges, fine, because I think the appeal cost ought to be added to it. Because we don't have a mechanism at the Court of Appeals to find facts. So if I can finish up on that, I think that's what you ought to do. The real nut of the coconut here is the declaratory relief. You decide that, and the rest of the case takes care of itself. Thank you. If there are no further questions?
No. You may approach. How do you turn it off? This thing. Thank you, counselors, for your excellent argument. The case has been submitted. Mr. Soar?
All rise. This session of the North Carolina Court of Appeals is adjourned.